Shepperson of Landlord Law, and I'm here today with Gary Leverett, who's a senior solicitor at Cozens Hardy.
Hello there.
Which is a firm of solicitors in Norwich, and actually the firm where I did my training many years ago.
Yes.
So, Gary, first of all, introduce yourself. Tell the viewers a bit about yourself and the work that you do.
Well, I've been a solicitor for 42 years. I've always been a litigation solicitor in one form or another. I have been involved in landlord and tenant work all through my professional life, although I'd say I've now been specialising in it for the past at least 20 years. I've worked in Norwich, in other firms in the city. I've also spent 5 years in London, which was a real eye-opener, and have returned to Cozens Hardy, and I've been with them for just over 5 years.
Very nice firm, Cozens Hardy.
They're a lovely firm. They're
Yeah.
a lovely firm with clients that go back generations, which is one of the things I really do like about it.
Yeah, I know when I was working here, it's a really good firm to do your training at. So.
Yeah, it's a good firm, very excellent lawyers.
Yeah.
From all departments.
So you've been doing landlord and tenant work for a very long time. How has the work changed over that period?
Well, when I first started, we had the old Rent Act, and their landlords had to prove a ground before they could evict tenants, and then we had the Housing Act come in its various forms with the old protected short-hold tenancies.
Yeah.
Before we've come to the current regime of short-hold tenancies.
So like me, you started when it was the old Rent Act. I can remember bringing eviction proceedings under the old Rent Act.
Yes.
So you do actually know how the Rent Act works, because a lot of solicitors don't really know the Rent Act at all.
I do know what the protected tenancy is. And although obviously we don't get too many, but they do crop up, especially in Norwich. You'll get some tenants who have been with people for 30, 40, many years. Yes, you have to sort of, to be honest, we do have to look it up again, but at least I know where to look it up, and the memory soon kicks in about how to deal with these cases.
So when you started, it was the old Rent Act. So then, fairly soon after that, the Housing Act '88 came in. So
not so soon after.
How have things generally changed, though? I mean, the sort of work that you do now from the work that you did then, and the sort of issues that you get clients coming in for. How have they changed over that time?
Well, initially it was. Landlords had the easier job of evicting tenants because of Section 21.
Yeah.
And it's two incantations. I mean, obviously, when you had the protected short-hold tenancy, you had the notice you had to have beforehand before you could rely on those, and then it was changed that you didn't have to have the notice. That's the main change, is that landlords are able to evict tenants provided they go through the various hoops. Without the tenant being in breach of their tenancy.
So what sort of questions and what sort of issues do landlords have now when they consult you?
Funny enough, the most frequent inquiry I get with landlords is in respect of gas safety certificates. And it may be because I did an article on the website, so when people do a web investigation, my name seems to come up. And you'll be surprised the amount of people who are in breach of gas safety certificates, which means that if they don't have a gas safety certificate, because they have an obligation to have a gas safety certificate, but more importantly, or as important, to serve it on someone who is when they market it, so before they review and that. If they don't do it, quite simply, they can't use Section 21 to evict the tenant.
Yeah,
which means they have to rely on a good reason then for evicting a tenant, which may be rent arrears, or which is the normal one, or it could be antisocial behaviour, or other ways.
Have you brought claims for antisocial behaviour? How have they gone?
Not for many years.
I know it's something I've always avoided.
The difficulty with those is finding independent evidence, i.e. neighbours who 9 times out of 10 do not want to get in. I have done it on the boot or the other foot in a social housing context. When I worked in Great Yarmouth, I used to do an awful lot of housing work for tenants, all antisocial behaviour, and I'm proud to say that I didn't lose a case.
Well done.
But that was in the good old days where we had legal aid.
Yes, well that's made a big difference. I mean, I used to do tenant work before we stopped doing legal aid, and now I work for landlords, which is equally nice.
Which is the same for me. I mean, we did very rarely take instructions from tenants because of the cost involved.
Yeah, which is unfair, but
It is unfair.
But there you go. So, do you do a lot of court work? How do you find court work nowadays?
I don't do so much court work, but I do have to have court work in these fields, especially if you're going down the rent-to-rear route, because you have to have a court hearing.
Yeah.
Courts have just got worse and worse and worse, and the court system is on its knees.
What are the main problems that you experience then?
Delay.
So it's mostly delay?
It's mostly delay.
Do they lose the papers?
Not so much in Norwich. When I was in London, when I worked in London, we used to issue a lot in the Central London County Court, which we used to call the black hole of the Central London County Court, because the papers were invariably lost there. And so you had to keep a paper file to back up those. Not so much in Norwich has never had that problem. At the moment now, it is, as far as I can see, it is the delay, which is lack of resources. Not only through staff but also judges, and the court buildings themselves. I think that is the problem. Getting things issued, the delay in getting issued, and it was absolute hell during COVID, because I had cases where you had landlords who had serious arrears of rent, and they could not do anything about it.
Yeah, I remember that. Yeah.
Couldn't do anything about it.
It's very unfair.
It was very unfair, because most landlords in this country are small landlords, in as much they may have one or two properties which they buy from their pension.
Yeah.
And rely on that money. Not only they rely on the money for that, but they usually have a mortgage, which in turn has got to be paid.
Yeah.
And a lot of them are in dire straits, but fortunately that's under the bridge.
Yeah.
And I hope we never see that again.
Yes. So, do you find now that you get more landlords looking to sell than you did before? Because there is a lot in the legal press about landlords quitting the sector. I mean, a lot of them will be landlords retiring.
Yeah. Yes, well, the irony is, you could probably remember that's why they brought in Section 21 in the first place, which was to encourage small landlords with the right to buy.
I think a lot of people don't realise that.
Don't realise that, no, because obviously beforehand under the Rent Act, you had to have a good reason to evict, and a lot of people didn't want to have that burden. As soon as you had Section 21, the small landlords had an investment opportunity, with the view that they could realise their investment pretty quickly, if needs must.
Whereas under the Rent Act, they'd lost them for years. I mean, I've had clients who had lost their property for 30 years, they couldn't get it back.
Absolutely. And so people forget that the reason for Section 21 was to encourage the right to buy market, to encourage rental housing, which worked. It worked tremendously well. And I think you are going to have the problem of the right to buy market shrinking, although the new act, the Renters Reform Bill Act, as I hope it becomes, I don't think it's as bad as a lot of landlords fear, because there are safeguards in there which we could probably deal with later.
Yeah. So, what do you think of the Renters Reform Bill, and do you generally approve of it?
I do generally approve of it. I mean, I think that there's the removal of Section 21, which is the 2 months notice, and that was a mandatory ground. If you gave the notice, went through the hoops and done it properly, the court had to evict you, whether you were the most brilliant tenant on earth or not. I found, I think you probably found, Tessa, when you're doing Section 21s, most Section 21s are usually served when the landlord usually wants to sell the property.
A lot of mine were for rent arrears as well.
Well, they are, right. Well, I found
and perhaps if there was an unsatisfactory tenant, then perhaps antisocial behaviour.
There is that, but there's an awful lot. But you have the safeguards under the Act, because you do have, again, sort of like a mini an alternative Section 21. It's not Section 21, it's another provision, another ground. Whereas if you want to buy the property, sell the property, you can serve 2 months. It's 2 months, not 4 months.
I'm not sure, I can't remember.
It's 2 months notice, but it must be legitimate. Because if you then do not sell the property or you then rent it out within 3 months, there are criminal provisions in that. So there is a safeguard like that. So I think there is that safeguard as well. But you've got the main safeguards, the tenants who are able to live in their accommodation, provided they pay their rent and behave properly. And which is, which is, I suppose, getting nearer to the continental system, which has long lets, whereas we don't. The other thing within the provision is you do not have fixed term tenancies anymore, they're all periodic.
It's going back to the old Rent Act.
It just goes back to the old Rent Act, it's ironic, isn't it?
But, Okay, so, probably wrapping up really, sort of thinking generally of the work that you do, is there some one main reform or that you think would really make things better? Just one thing, if it came.
It's not a reform. I can't think of a reform at all. But the most important thing I feel is for the government to properly resource the court system. As I said earlier, it's on its knees. It really is. It lacks investment. There is so much delay in getting court cases heard. And especially it's going to be even worse under the Renters Reform Act because you're going to have court proceedings.
Yeah, that's right. Section 21
You can't do
right?
Section 21. If people have got rent arrears, you've got to go for rent arrears. If they're antisocial, you've got to go for antisocial now. Which means you're going to have a court hearing. If it's defended, it means more delay. And that's the problem, is the delay. And I think that is the greatest thing that anyone can do, the government can do, is properly resource the court system. Unfortunately, that's not going to happen.
They've got to properly resource the schools, the National Health Service, pay more money for defence.
In fact, there is going to be less money in the justice system anyway. Isn't there going to be cuts because of the last budget? But that's another matter. Whether that will change under the if there is a change of regime remains to be seen. But that is the best thing. Resource the courts properly.
Well, Keir Starmer was a barrister, so maybe he will have some sympathy with that view, hopefully.
Well, he was a prosecutor, but he's a human rights lawyer, wasn't he? But hopefully.
So, just to wrap up, what if you were to give 3 top tips for landlords, what would they be from your experience?
First of all, know the law.
Yeah.
So many landlords come to me, they have not a clue about the law and they get themselves into an awful lot of trouble. The most important glaring example is the lack of gas safety certificates or EPCs, which they have to have. That's the biggest trap they do. I would also say try and understand or know your tenant, i.e. you need them to pay rent and you've got to, I know it's impossible 100%, but have an idea with regards to what they do. Take legal advice. Look on the web. There's some great sites. One of which is the Landlord Law, set up by Tessa. And I'm not just saying that. It is a brilliant resource. But they're the 3 tips that I would give.
Okay. Well, thank you very much, Gary.
Thank you, Tessa. It's lovely to see you again.